ask some questions of the Hauling and the Knight attorneys. And we'll start out, Joyce, if you do a roll call, please.
Dave Talley,
Here.
Tammy McDonald, Alyssa Devon,
Here.
Michael Dixon,
Here.
Mark Bymaster,
Here.
Kathleen Weigel, DeAndre Campbell.
Here.
We have a quorum.
Okay, thank you. And now, as always, we'll do introductions, and we'll start down with Blair.
Blair Littlejohn from the Office of General Counsel. Frank Barbieri, School Board.
Heather Frederick, Chief Financial Officer.
Jeff Shacknow. Morning, William Shepard, Conflict Inspector General.
Emmy McDonald, Audit Committee. Alyssa Dobbin, Audit Committee.
Why don't we go, before we go to you, Oscar, let's go over to the side and have everyone introduce themselves, please.
Morning, Patricia Morales from the Office of General Counsel.
Good morning, Erica Whitfield from the School Board.
Good morning, Marcia Andrews, School Board Member. Good morning, Karen Brill, School Board Member.
Okay, now, Oscar.
Oscar Restrepo, Director of Investigations, IT's Office.
Dave Talley, Audit Committee.
Teresa Michael, Inspector General.
Carrie Hyde, Counsel for Inspector General.
Joyce Edison, Executive Assistant.
Michael Dixon, Audit Committee.
Mark Bymaster, Audit Committee.
Annette Pinnock, Accounting Director.
Okay, thank you. I've got a few opening remarks, and we'll start out with the role of the Audit Committee as being governed by Board Policy 1.091. The Audit Committee is charged with, among other things, serving on behalf of the school board as its oversight of the school board's Inspector General, internal audit, and investigation functions. Its members rely on the representations of management, the Inspector General, the General Counsel, and other professional consultants. The Audit Committee shall review and make recommendations to the school board on matters affecting the adequacy of internal controls, accounting procedures, systems and controls, and financial reportings and accountants in accordance with laws and regulations. The Audit Committee is convening this morning after our March 17, 2023 meeting to discuss a report that was issued on February 9th of this year by Mr. Bill Shepard, a lawyer for the law firm of Holland and Knight, serving as a conflict inspector general. By a vote of the committee, we decided to hold and review any recommendation of the report to provide Mr. Shepard the opportunity to answer the committee's questions so that the committee may effectively serve its oversight function and make recommendations to the school board. Each member of the committee has a booklet containing the exhibits. But before we begin, I'd like to take a moment and establish which records provided the basis for Mr. Shepard's engagement with the district. First, on January 28, 2022, Inspector General Michael and General Counsel Bernard were served with two memoranda. These memos were sworn to and provided as subject rebuttals to the draft IG report regarding alleged retaliation, which is report 20-0012-I. Both memos indicated the subject sought whistleblower protections under the law. These two memorandum are in your March 17, 2023 packet, marked Exhibit A under tab 5A, and are 20 and 17 pages respectively. These memos contain many allegations, many of which critical of the underlying retaliation investigation and the IG's findings. However, other allegations, including violation of the law, retaliation, conflicts of interest, and abuse of power by the superintendent, the inspector general, and the board. These allegations include, but were not limited to, the IG engaging in unethical and inappropriate conduct, board member or board members traveling overseas with and receiving campaign contributions from underlying investigation complainant's family, the superintendent engaging in discrimination, and other general wrongdoing. It was these allegations of wrongdoing against the Inspector General, Board, and Superintendent that brought the district to engage Mr. Shepard. When allegations of corruption are made against any one of the combination of the Inspector General, Superintendent, Board, or General Counsel, board policy requires investigation by an outside entity. Board Policy 1.092.7 governs the use of external conflict agencies and the authority under which Mr. Shepard was selected to investigate the allegations contained within the memos comprising Exhibit A against the IG, the superintendent, and board. Pursuant to Board Policy 1.092.7, a governing external conflict agencies, and through Board Agenda Item ILD2 from February 23, 2022, which is authorization to hire an independent investigator and outside counsel. This agenda item is included as Exhibit B under tab 5B. Mr. Shepard's engagement contract was executed on March 8, 2022 by General Counsel. This contract is included as Exhibit C under tab 5C. The final report dated February 9, 2023 is included as Exhibit E under tab 5D, and a follow-up email included as Exhibit F under tab 5F. Exhibit E begins by stating, the School District of Palm Beach County, or known as the School District, engaged Holland & Knight as Conflict Inspector General to review allegations that former district employee Robert Pincos, Mr. Pincos, was retaliated against by current or former members of the School District Human Resources Department and the Human Resources Department were responsible. The report's findings largely review the work of the IG and its conclusions in the original IG investigation, 20-0012-I, which the memos, Exhibit A, were written in response to. The report was nearly silent as to the allegations of corruption that triggered the hiring of Mr. Shepard. The purpose of today's meeting is, in part, to determine how, with detailed fact-finding based answers, the initial memos, Exhibit A, served on the Inspector General and the General Counsel on January 28, 2022, resulted in the report Mr. Shepard provided on February 9th of this year. Attached is Exhibit D under tab 5D, and a follow-up email included as Exhibit F under 5F. Differently stated, as the oversight body of the Inspector General and advisor to the board, the Audit Committee must determine whether or not Mr. Shepard's report adequately addresses the corruption of the Inspector General, the board, and superintendent alleged within the memos attached as Exhibit A. As previously discussed during the March 17th Audit Committee meeting, at the close of today's meeting, we will be expected to make a recommendation to the board regarding this report. Some options for committee recommendations include, but aren't limited to, number one, recommend the board to accept the report. That is, the report is sufficient, complete, and the committee has no outstanding concerns. Number two, recommend the board reject the report. That is, the report is insufficient, incomplete, and/or lacking material information. Number three, recommend some combination thereof. Recommend the board accept the report or reject the report with further recommendation that an external entity investigate the complaints against the IG, superintendent, and board outlined in memos Exhibit A. And then any other recommendations that the committee believes are necessary to fulfill the obligations under this policy. At this time, I'd like to ask Ms. Shepard a few questions before we open the questions to the committee. Ms. Shepard, did you write this report alone?
Whoops. Good morning, Mr. Chair. As you said, my name is William Shepard. I'm the Conflict Inspector General. I'm here to present my report. I'm also glad to answer your questions. To your first question, did I write this report alone? I wrote it in conjunction with my colleague who is here with me, Mr. Jeffrey Shacknow.
Okay.
We also received assistance from a paralegal who assisted in the project, and perhaps other office staff personnel, but I am essentially the author of
Okay.
the report.
Is the report based on your understanding of the law and relevant board policies?
The report is based on over 20 interviews that I conducted, along with Mr. Shacknow, the targeted review of a mass volume of emails that were relevant to the topic, the review of the report, and my view as the independent conflict inspector general on what the appropriate steps were to take in investigating those two reports that you discussed. And I believe that I did that appropriately.
Okay. Does the report effectively apply the law and policies of the facts and information gathering during your investigation?
Yes, I believe that I have applied my 20 years of experience in prosecuting, investigating, and handling matters of corruption, both as the statewide prosecutor of Florida, a position I held for 4 years, as the former statewide grand jury legal advisor as appointed by the Florida Supreme Court, which led an investigation into corruption at the Broward County School District, which was really my first entree to school district management and issues within districts. I believe I do have a strong familiarity with the criminal laws of the state of Florida, those implicated here, whether they might have been illegal gratuities, improper bribery, or any of those issues as it might have been related to the inspector general, members of the school board, and/or the superintendent, both former or current. I believe I answered your question, but if I didn't, I'm...
Is this report based on a complete evidentiary record?
This report is based on the evidentiary record that I felt needed to be developed. Again, as I said, I spoke to over 20 witnesses, I and Mr. Shacknow independently. I reviewed the documents that I pointed to, and I believe that was a complete evidentiary record for me to determine whether or not there was corruption as alleged, and to substantiate my finding that this was a factual error in the investigation and not an issue of corruption by any of those alleged to have been involved in corruption, whether, again, it was the superintendent, members of the school board, or members of the IG's office. I found no evidence to support corruption in those alleged. What I found instead was the detailed shortcomings of the IG investigation, which I believe led the complaining witness to assume incorrectly that it was faulty because of corruption. I believe it was just faulty because of the reasons I outlined below, and found no evidence to support any allegations of corruption.
Is the report accurate?
Yes, I believe that it is.
Okay.
I did receive public comment as I sent it out to those who were identified. I received comment from the Palm Beach School District Inspector General. Her comments were attached. I received comment from the outside counsel hired by the school district, Mr. Tom Gonzalez. He said it was accurate as to him. I don't believe that was included in your previous materials, but it's part of my report. I received comment back from the Pinellas Inspector General. She identified that my comments as to her office were complete and accurate. I received no comment back from Vicki Evans-Perret, but I did receive comment that she had no objection to the release of the report without redaction. And I did receive comment from Dr. Gonzalo LaCava. Dr. LaCava's comment was critical of the report, which I don't believe was included in the materials you received. His criticism, which is part of the record, which I attached, was critical in one respect. He said, "I appreciate the time and thoroughness that was presented in this draft report, but there's one section I would like to refute." And Mr. Chair, as part of the IG process, you go back and forth with the witnesses or the targets or subjects of the investigation so that if there are factual errors, they can be corrected. His area which he thought needed to be corrected was my commendation of the IG's office for a correction of an error in their draft report as it related to Dr. LaCava. I said that that's how the process is supposed to work, and it's good that the ultimate decision was the correct one, which exonerated Dr. LaCava compared to the draft report. He was critical of my finding in that regard. He said in his letter to me, essentially, I had to do the OIG's work for them. It fell to me to develop a factual record and to highlight key documents and facts that the OIG ignored. Again, while I'm grateful that ultimately the right decision was made, an effective process would have reached that decision without my having to expend significant time, and effort to correct the OIG's mistakes. But I believe my report was correct, his distinction notwithstanding.
Are there any errors or omissions in the report?
There were two factual errors. One as it related to a timeline that was presented within the report. And the Inspector General pointed out that although the sequence was correct in the timeline, there were some dates that should have read 2019, I believe, and instead read 2020. So that was factually inaccurate in the draft. There was also another section that pointed to, I believe it was Section 3, which the Inspector General pointed out was correctly Section 3A. But other than that, I believe there are no factual distinctions, and those have since been corrected based on the input of the Inspector General, which I appreciated.
Okay, thank you. Are there any corrections, modifications, additions, or deletions to the February 9th report that you need to advise the committee of before we begin?
No, I'm glad to present my findings orally, or I'm glad to just answer questions. I believe that the report is complete, that it outlines the fact that there were flaws in the investigation. It was those flaws that led the subjects of the investigation to believe that that had happened solely as a result of corruption, as detailed before in our earlier discussions. I believe there is no evidence to support that, and that the errors were just that, errors, not for any ill motive.
So the final complete report was submitted on February 9th, 2023, is that correct?
That's correct, and then as you pointed out in a packet that you have for your committee members, I received a question from the General Counsel, and I replied to that. I believe you have that email also in the materials. I was not provided a copy of those materials, but I believe as I was listening to your inventory of items that was one of those. So yes, I would say that's correct.
Thank you.
Yes, sir.
Okay, committee members, some questions for Mr. Shepherd. Tammy?
Okay. Good morning.
Good morning.
Thank you very much.
Yes.
One of the questions I had to do with the whistleblower, and if you indeed made a factual determination, or how you went about making a determination that that person met the standards of whistleblower, and what protections were offered under the standards and the law and so forth for the whistleblower, number one. And then secondly, two questions.
Sure.
You indicated that in your memo of February 22nd to LaToya Bernard that there were specific investigative steps that were overlooked or not considered. Are you prepared to detail what those specific steps were? Because we keep talking about in generalities as to things being overlooked, and I'd like to know specifically what your findings, resulted in.
Yes, I'm glad to do that. If perhaps it'd be easier for me to answer the second question first, if you don't mind. Vicki Evans-Perret filed a complaint with the Inspector General, and which led to the complaint, which was directed to me. The findings of the Inspector General's report were that she had retaliated against a subordinate, that a subordinate named Robert Pincos had filed a complaint against her because she had instructed him to handle an investigation. He refused, said that he had a conflict and should have been able to recuse himself. At the time, Vicki Evans Pare was consulting with outside counsel that had been hired by the district to advise on this. You may recall this had to do with Principal Latson at Spanish River High School and the issues related to Holocaust education here at the district, both a statutory requirement, but also an issue that the district cares deeply about and ingrains in its education. So the issue had to do with whether or not Vicki Evans Pare retaliated against Bob Pincos when he refused to do that investigation. Because at the time, the investigation needed to be done, right? Mr. Pincos said he wasn't going to do it. Vicki Evans Pare picked up the investigation and completed the investigation along with a team of people and advice of Tom Gonzalez, a former school board attorney at a large metropolitan school district. That's one piece of the story. The other part is that Bob Pincos then, in my view, unrelated to that, is transferred from this building to a location in the South County, in an area, a school area where he has jurisdiction for. The investigators are assigned different parts of the district. This was a part of his district. Vicki Evans Pare transferred him there at the advice and suggestion, as detailed by the IG, of Chief Kitzrow, who was then the police chief for the school board. That happened as a result of an incident that happened here in the parking lot. Dr. LaCava was getting out of his car. Dr. LaCava had refused to meet with Mr. Pincos earlier because Mr. Pincos had said, I want to meet with you to talk to you, and I want to record the conversation. Dr. LaCava said, I'm not prepared to meet with you if you're going to record the conversation. I'm taking it off my calendar. We'll deal with this separately. Mr. Pincos was upset with that, approached him in the parking lot in the morning. Dr. LaCava has testified or has identified that he was in fear that morning, that he was accosted. He wasn't battered. He wasn't threatened that he was going to, come to physical harm. But he was in fear that morning as he got out of his car. He was intimidated. Witnesses in the parking lot heard the yelling. They went in and they talked to people here at the front desk of the building. And the chief, in consultation with Vicki Evans Pare, suggested that Pincos needed to be relocated. So in doing an analysis of that, the school board hired the Gunster law firm to examine that parking lot situation. They couldn't have the HR department investigate it because it involved people in the HR department. So they hired the Gunster law firm to conduct that investigation. Investigators from Gunster came out, interviewed people, and reviewed the written materials. They said, based on their experience, that this is the sort of workplace violence issue that could lead to problems. And I don't want to misstate it, but they said it's the type of behavior that could lead to acts of violence in the workplace. So, in my mind, with the chief of police instructing that Mr. Pincos should be relocated, with the internal investigation from the Gunster report saying that this is the sort of thing that could lead to violence, it was important to ask other people, including LaCava, whether he was concerned about it. I spoke to other of the witnesses about the policies and practices of relocation of employees within the district and learned that it's very factually specific, but that it does happen. And those facts flew in the face, in my mind, in the investigation that I conducted, with a finding by the Inspector General that Bob Pincos was moved out of this building to another building for retaliation for his failure to do the investigation into Dr. Latson. I feel he was moved out of this building because the police chief said he should be moved out of this building, because Dr. LaCava, who worked with him closely, was concerned about working with him closely, and because independent witnesses who were in the parking lot that day felt that it was a real situation and a real incident. So a finding, almost as if that was not a real incident and that the movement was pretextual as punishment for refusing to do the Latson investigation months earlier, was just not supported by the facts. And that Vicki Evans Pare moved him because he needed to be moved, as the experts had advised her, not because she was out to get her subordinate and make his life more difficult. So that's one of those issues, I think. And it's not just this was Vicki Evans Pare's side of the story compared to Mr. Pincos' side of the story. There were multiple other people who were involved. The Inspector General gave no what was referred to as evidentiary weight to the Gunster report. And the feedback I got from that was because the Gunster report cited secondary sources. Well, I spoke to the law.
Excuse me, could you,
Yes.
could you tell me what that means?
Yes, I'm going to. Right. So it's an excellent question, right? So the Gunster report, the lawyers from Gunster actually came and interviewed people who witnessed it, right, and were involved. The Inspector General believed incorrectly that the Gunster investigators had relied on written reports by the witnesses that day that were attached. No one from Gunster was ever spoken to, according to the lead investigator at Gunster. And the Inspector General's view was that they had not actually come here to interview people, that they had not spoken to
It
people.
was secondhand?
That it was secondhand, right?
Okay,
Yes,
I'm following.
right. But it was not. They had actually been here. Now, it's an after-action report, right? They weren't the eyewitnesses, I understand that. But it really made it difficult to draw a conclusion that this was pretextual. Vicki Evans Pare didn't make it up, as it were. It was a real incident that happened. And particularly in this day and age, when it comes to workplace safety or school safety or any of these things, if she had contradicted the role of, or the advice of the law enforcement as it related to this issue, I think that would have been a very serious thing for her to have decided to do. And she instead decided to follow the advice of the police chief. So that would be one example. Another example had to do with the scope of Bob Pincos' investigation, right? So Bob Pincos conflicted himself off the investigation into Principal Latson because he said that the scope of the investigation need to be expanded. And if it were expanded to look at the entire Principal Latson issue, it would have implicated his wife's supervisor. Not uncommon in the district. There are family members who work with one another, very common in this type of setting. The district did not have good recusal policies, right? That was a real issue that was addressed, and the Pinellas IG focused on that, and changes have been made, and there now are recusal policies. The IG report was correct that that was an area that could have been improved and should have been. But Vicki Evans Pare was relying on advice of Tom Gonzalez, an outside expert, in this time of crisis. If you put it in context, July 5th, the newspaper article from the Palm Beach Post runs. The district had known it was coming for some time. The school board members did not. The issue had been dealt with by administrators within the school district back in 2018. As soon as the email was first put out by Principal Latson with the parent involved, administrators within the district were involved in 2018. Board members were talking to the administrators to make sure that it was being addressed and had been assured that it was. Principal Latson was sent to the Holocaust Museum as part of a program to further ingrain upon him the importance of not only meeting the statutory obligation, but the importance that the district rightly places on these issues. The curriculum was reviewed. A series of meetings were held over a course of months, literally, at the Spanish River High School with those involved and with the curriculum to assure that Holocaust education was getting its appropriate part in the curriculum in that district, but also in that school. So what Pankos wanted to investigate was, back in 2018, was that handled properly by the investigators? That could have impacted his wife's boss, Keith Oswald at the time, right? But what the mission was at that time, what the focus was at that time, is we have one situation where the article has hit the White House, the governor's office, all sorts of people want to know what's going on here, and Dr. Latson's not answering the phone. Principal Latson's not responding to emails from the district. He is ignoring our request for him to be involved. That was the scope of that investigation. Principal Latson also sent out an email during this time period when he wasn't communicating with the district. He sent out an email to the Spanish River community and faculty, essentially blaming the parent. So the narrow focus that needed to be dealt with at that point was, during this multi-week period, has the principal acted appropriately? Has he been truthful with us about his whereabouts? Has he been diligent in responding to administrators who need to speak to him about this very important issue? So a question of whether or not in 2018 the supervisor of your wife handled the dealings with the parent on campus might be important and interesting, but is not relevant to the legal question of, during this 3-week period, has he acted appropriately? So Vicki Evans-Pare is a lawyer herself, deals with these sorts of issues, but relied extensively on Tom Gonzalez, the outside lawyer who was retained by the district, who had experience in helping districts around the state, certainly, and perhaps around the country. I don't know that, but certainly around the state. He is a very well-respected and highly regarded person in this area. And he was telling Vicki Evans-Pare, you essentially have a double jeopardy type issue. You can't go back and look at the 2018 material. The district has already dealt with that. You can't discipline him for that. There are issues that are related to the how that was dealt with. There might be lessons learned, but that's not the issue of discipline. The issue of discipline is, what has he done during this 3-week period? So Vicki Evans-Pare is again relying on expert advice, which is telling her what to do. She is following that advice, and she's saying, Mr. Pankos, we need to focus on this issue and this 3-week period or month-long period. So Pankos says, I can't do the investigation. I'm not going to do the investigation. She asks him repeatedly to put his concerns in writing. He eventually does. Was there frustration with that? Absolutely, there was frustration with that by Vicki Evans-Pare. She actually, when he claimed that he was going to recuse himself, she yelled at him. She later apologized to him for that, and she went and self-reported herself to her supervisor that she had behaved inappropriately in yelling at Mr. Pincos that, I believe it was that morning. So that's the backdrop, and I could understand why when you put these various things in a timeline, it could look like it's retaliation, that she moved him out and put him in a different place. She had to pick up the investigation. She wasn't getting support from her colleagues on it, and her role was to manage that, not to do the investigation herself. So when we reached out to Tom Gonzalez to talk to him about this, no one had spoken to him about it. When we asked him if he had any written materials that would support Vicki Evans Pere's position that she was following the advice of Tom Gonzalez, he said, well, yes, I have this big file right here that no one's asked for. So those were significant issues in my mind that were supportive of a factual basis that Vicki Evans Pere was not sort of out cowboying on herself and doing this and upset with Bob Pincos in a way that was inappropriate, or, I mean, it was inappropriate that she yelled at him, but she was trying to get the job done that the board needed done, that the superintendent needed done, and it really didn't implicate the 2018 issues. So there was another, and it's sort of a third sort of, I don't want to say extraneous issue, but there was a luncheon that Mr. Pincos went to during work hours. It's a school board type event. It was an awards luncheon, the HEC awards luncheon. I believe the chair was receiving the award or was a speaker. The school board had a table. Mr. Pincos's wife was very involved in the planning and engagement of it. It certainly was a school-related function, but he had not filled out the appropriate duty elsewhere slip to account for the fact that he was going to be driving across the county to go to this event for a roughly 4-hour period. Should he have filled that out? Yes, school board policy requires it. Does every school board employee fill that out every time they drive somewhere that they need to fill it out? That was beyond the scope of my investigation, but the comments I got back from others was that it's important. We do have to counsel employees on it all the time, but it does happen. So he was written up for that. Now, the timing on it is sort of consistent with the Inspector General's findings that, oh, this was retaliation, and that you wrote him up in retaliation, you moved him out of the headquarters building in retaliation because he wouldn't do the investigation that you demanded him to do. I didn't find that. I found the opposite. I found that there were justifications for each one of the actions that Vicki Evans Pere took, other than yelling at him that morning, and that the factual record was just not completely developed on those issues. To have not spoken to Tom Gonzalez, to have not gotten those files that really were Vicki Evans Pere's support for why she did what she did. But instead, if you read the Inspector General's report from the school district, it's almost questions her credibility on whether or not that was a legitimate thing, and it refers to it as her answers are incongruent. Well, she was following the advice of the expert that had been engaged by the district.
Mr. Shepard, if I may interrupt you just for 1 second, because I believe that I may be grossly confused. Tom Gonzalez provided legal counsel regarding the Latson investigation, correct?
Yes.
He did not provide legal counsel to Vicki Evans Pere regarding the memorandum that she wrote for insubordination against Bob Pincos, did he?
No, I'm talking about the investigation and the scope
Right,
of
no,
the investigation.
I understand that.
And I'm trying to answer Ms. McDonald's question.
I know. I just want to make sure that I'm understanding. I reviewed this as well beforehand, and I was pretty clear in all of the advice that Tom Gonzalez gave was not related to the actions that Vicki Evans Perry took through her November 15th memo, transferring and citing Mr. Pincus for insubordination. I just want to make sure I understood that correctly.
Yes, you're correct.
Okay.
He didn't give any advice to her about whether she should move Pincos out of
Okay.
this building. That was the police chief who gave that advice.
Did he?
Well, the IG report confirms that that's what he says, so that he should be relocated.
Would you be surprised that Chief Kitsero, during his interview, said that probably the transfer took place at his recommendation? Would that fact surprise you? There were no reports written by Chief Kitsero, were there?
Mr.
Hi.
Mr. High, there were no reports written by Chief Kitsero.
Okay.
The Inspector
You
General.
never interviewed Chief Kitsero either, did you?
We made multiple requests. At the time he was an employee, when your office was investigating him, you certainly would have had that authority to bring him in.
We did. Did you listen to that recording of Chief Kitsero?
Mr. High, I'm trying to answer your question. We made multiple requests to speak to Chief Kitsero, both in writing and by phone. Although he spoke to us briefly and said he would get back to us, as a former employee of the district, I didn't have the ability to compel his testimony, as it were. And so he did not get back to us after repeated requests, which is what we document in the report. That we made that attempt, he would have been an important witness to hear from. I totally agree. But the IG report, I believe, supports our statement and my statement here today and your statement moments ago that probably that's what he did. Vicki Evans Perret did not create a fake reason to move him out of the office and put him in a different location.
Again, would it surprise you?
If I could just finish her question.
Okay.
And then I'm glad to answer your question.
That's fine. I just wanted to make sure I wasn't
If I may,
misunderstanding.
maybe you should start answering her question. She asked a specific question about whistleblower. You have not done anything. You've done a lengthy soliloquy of what you found, which was, you state as facts, which I mean, notes is factually incorrect. Can we just get to her question?
Mr. Restrepo, I believe I said I was going to answer the second part first, and then I was going to answer the first part, which is what I'm going to do right now. But I appreciate the input from both of you. So Vicki Evans Perret initially identified herself as someone who was seeking whistleblower protection. When the Inspector General said she was not going to attach Vicki Evans Perret's comments and rebuttal, as it were, to the an initial report by the Inspector General because she was a whistleblower, Vicki Evans Perret said, I no longer seek that. I want this to be public. I want my response to be public. When I spoke to Vicki Evans Perret, her greatest concern was that this investigation would not be public, that this report would somehow be shelved and would not be out there. She has given full authorization for the report to be released and for it to be released without redaction. So my view is, could she have qualified for whistleblower protection earlier on in the proceedings? She could have. She was an employee. She was making a report about alleged criminal conduct. Did she seek that protection ultimately? No, I don't believe that she did.
May I ask about Dr. LaCava? He also requested.
You may. So Dr. LaCava also, as I pointed out in my report, he was, hang on. I just want to get the date right. So in his letter of January 6th, it was also his interest, both through himself and through his lawyer, that these reports be public and that essentially his name be cleared through this report. I believe it was not my job to either clear his name or not, but was just to report on the facts. The fact that I am an outsider, the fact that I have no relation with the district, either personal or professional, is what gives me the freedom and the ability to do that. In this case, I made a finding that the IG report 2012 was lacking and that it did validate his concerns along with Vicki Evans-Pere's concerns. Now, as I pointed out in my report, Dr. LaCava was ultimately exonerated in the final draft because there was a question about whether or not Dr. LaCava had also retaliated against Bob Pincos by moving him from this headquarters building to another building. It was made clear to the Inspector General that he actually didn't have that authority. It was actually Vicki Evans-Pere who made that decision, and it was her decision alone. And so because of that, the ultimate report cleared or exonerated him in that sense. So I believe I've now answered both your questions. I'm glad to discuss either part further or take other questions.
I think we have a question of Mr. Camel. Did you have a question?
Yes, I did not, if I may ask Ms. McDonald, because I wrote the question to, I don't feel I have an answer to the question on those specifics that were asked of Ms. McDonald.
So my understanding would be that the specific steps that were overlooked in the IG's investigation has to do with the full investigation of the parking lot confrontation and a follow-up of the Gunster report, which resulted from that confrontation with direct interviews of those that were involved. That was what I basically got from what you shared. Is that correct?
That's certainly part of it. And then the other part is the Tom Gonzalez piece where Mr. Gonzalez wasn't interviewed and his involvement was discarded as not a legitimate basis for Vicki Evans-Pere's view of the proper scope of her work.
If I may respond, there were 3 issues having to do with Mr. Pincos and his recusal. One was he had a stated bias, that he said that he called Dr. Latson anti-Semitic, that he was an idiot, that he shouldn't even be a principal in Alaska, I think was one of his comments that he made. He also commented that he felt ethically conflicted in order to do the investigation because he felt that this was a targeted event. We did not interview Tom Gonzalez because the scope could be fine. The fact that Mr. Pincos felt ethically conflicted was the issue, that he reported that ethical concern to his supervisor, who was also in charge of the ethics, and then was disciplined for recusing himself, was the problem. Plus, another employee also recused herself for the same reasons, and no action was taken against her.
Were you aware of that, sir?
Yes, and excuse me, yes. And Ms. Michaels and I agree on 85% of what she just said. There needed to be a recusal policy. There needed to be opportunities for him to make that recusal, which he did. I don't know that every investigator comes to, particularly in a setting like this, where investigators may know in passing or having worked with lots of people within the district over a career, that should be the sole basis for it. But whatever it is, that needs to be spelled out as a policy. And I agree with Ms. Michael that that was a shortcoming. What I disagree with Ms. Michael is that he was later punished by Vicki Evans-Pere for that recusal. Should he have been able to recuse himself? Yes. Should there have been a process for it? Yes. She and I are in 100% agreement for that. Was he punished because he recused himself, and did Vicki Evans-Pere misuse her authority? No, I don't believe that she did.
We based the punishment on the memorandum, the negative memorandum that he received in his personnel file. That is what we determined was the negative, the retaliation that was given to him, I think 3 months later. And it was based on his recusal, which she called insubordination for refusing to do the investigation.
I had a quick question just for timing. How quickly after the parking lot was he moved? Like, I'm not clear on that. I'm just curious about timing of some of this.
1 week.
So okay. And then the recusal happened 3 months?
Months earlier.
Yeah,
okay.
much earlier.
I just wanted to make sure I was clear on how quickly this all moved.
And the timeline, frankly, when I first read the report, the timeline made sense with the stated findings. Because the timeline of when Vicki Evans Pare filled out these various, the memorandum that you're talking about, they all sort of, it was almost as if the file had been papered later after the decision had been made, right? Which could lead a person to believe that it was done for improper reasons. And although that timeline was consistent, I find that in this case, it was just an indicator, but it was not the ultimate issue. The ultimate issue had to do with the other points that I've addressed.
Did you perform an investigation of the other investigator who recused themselves and determined that there was a different handling of their employee file and so forth, and action against them, or was there any action against them at all?
So the other employee recused very quickly. I don't know if it was the same day, but it was in short order. Mr. Pincos was involved in the investigation for several weeks. But again, my belief is that Mr. Pincos was not moved to South County because of any improper issue.
Excuse me. What is the answer? What's the answer?
So the answer is no, I did not.
Okay.
I did not speak
That
to,
was what she's asking.
I did not speak to that other investigator.
I feel like he's saying it's different, though. I mean, the one.
He is saying it's different, but I'm one of the.
I think when you
yes or no.
recuse the same day is different than you go into the process for 2 weeks and
Yeah.
then recuse yourself.
Yeah.
I mean, that's,
But I didn't speak to her. And there may have been other people within the district over the course of the last 5 years who have recused in other matters. I didn't investigate that either.
Did you, may I ask a question?
Sure.
If the chair would like you to, yeah, I'm glad to answer.
Yes. Mr. Shepard, did you listen to the interview of that employee, Brenda Johnson?
I don't know that I did.
Did you listen to any of the interviews of the employees in this case?
I don't know that I can't, I did not personally. Did someone on my team? I don't know the answer to that.
May I ask Mr. Shacknow, did you?
Well, let me finish my answer. We conducted in-person interviews with people, right? So I wanted to ask the questions myself, and we may have reviewed some audio tape interviews of some people that you did, but I don't know the answer to that.
Mr. Shacknow, did you listen to any audio recorded interviews?
I did not listen to an audio recording for Brenda Johnson. For many of the, I did not listen to an audio recording of Brenda Johnson. For many of the folks that had been interviewed previously, there fortunately were quite a bit of written materials about what they said. For Brenda Johnson, for example, there was no discrepancy, I think, about what her stated comments were. The report that your office put together outlined that clearly. The distinction that Mr. Shepard made was that Mr. Pincos did begin investigating the Latson issues, started preparing documents and paperwork, and then told his superior he wasn't going to do it and turned that stuff in.
Now, yeah, I'm sorry. Are you finished?
I am finished, yes, thank you.
So I want to make sure again that I didn't miss something. I want to be good at my job. And I have to be very frank that in reviewing all of those recorded statements and in reviewing all of the policies, what I saw as a fellow lawyer, there was an ethical concern that was expressed by 2 employees regarding this investigation. One was right out of the gate. Another was, I believe, early on, but then directive was given by Ms. Evans-Perry, go back, keep working on it, do what you can, document. And as he continued to work on it, the ethical concerns grew, and ultimately, that second employee, Mr. Pincos, recused himself as well. Right?
I agree with that.
Okay. So he follows the code of ethics that you said at the beginning when Mr. Talley asked you if you're familiar with, right, the policy here. He then reported that pursuant to policy to the one person that the Code of Ethics requires you to report it to, his supervisor, the Director of Professional Standards, Ms. Evans-Perret, right? He says, I've got this ethical concern, this is what it is, he's expressed his biases, I can't continue with this investigation. Explain to me how, if we have a policy that specifically states the school board, its employees and agents are prohibited from taking retaliatory action or, and this is important, adverse personnel action against any employee who reports violations or discloses information under this policy. If we later on, 88 days later, have that same employee, Mr. Pincos, being served with a memorandum for insubordination for reporting that ethical concern, similar to Ms. Johnson, and recusing himself, how is that not a violation of this policy?
Excuse me. I think that the distinction between the two different employees is important. But I think that ultimately, when you look at the entire scope of Vicki Evans-Perret's dealings with Mr. Pincos, repeatedly she told him, Bob, if you have a concern, put it in writing, right? If you want the scope to be expanded, tell me what you want to investigate. Tell me what you want to put in writing. She made that request to him several times while the investigation kept going on. And if you recall, did
he do those things, though? Did he put it in writing?
He ultimately did after multiple requests.
Okay.
But the scope of what needed to be investigated that day, in that moment, was Principal Latson's failure to communicate back with the district. Principal Latson's email to the Spanish River community. It was not, did the district handle this appropriately back in 2018?
Right, and I agree with that. I don't know why we keep talking about that. My question was, though,
Well, I believe it's important.
I believe it's important as well, but my question, because like I said, I'm asking because I feel like I blew it. You know, you were called in to look at corruption by the IG and unnamed board members and the superintendent. And the only thing that I've noticed in this report is you were critical in reviewing our work. And so that's why I want to make sure that I'm not missing something legally, factually, substantively, and I'm struggling to see that.
Well, I think when you look at the question of was there corruption, did the superintendent improperly manipulate your office? Did board members improperly manipulate your office? Or did, for whatever reason internally, your office come to these conclusions that I believe were flawed? What was there corruption to that? My answer is no.
But that's not in your report, though, sir.
I'm just reporting it now.
No, but there's a 22-page report or 28-page report that doesn't say that.
And hundreds of pages of exhibits or more.
But the report doesn't say that, and that's why I'm struggling to understand why that is.
Mr. Chair, Leandre here.
Yes. Go ahead.
Through the chair to Mr. Shepherd, considering what was just stated, is there a space in your report to add that modification or that information that Mr. Hyde just spoke about?
To add the modification that there is no I make a finding that there was no corruption by any of those alleged?
Correct.
Yes, and I have responded to the general counsel. I believe it's a part of the record that was identified by the chair and the materials that are before the board members present. But
There's an email that addressed that, of course, and I read that email, but that if it's only in that email, nowhere else in your report does it state that. So if we don't talk about, if it's not in the report, other than embedded in the email, no one's going to review just that email stating that.
And I understand that, and if it would be helpful to the committee, I'm glad to make an addendum that would find that or include that. But what my findings were that there were errors. Had there been corruption, my findings would have been that there was corruption that forced these errors. I found no evidence of that. No evidence of corruption on behalf of any of the board members as alleged. There are, either the report is 100% accurate and correct, and therefore the allegations of corruption are false, or there was corruption which led to an improper report. Those are the two extremes. I found in the middle that there were errors in the report, but they were not driven by corruption. And I felt it was important, in order to fully air that out and make that finding, to identify what those factual errors were.
Mr. Barberry?
Let me just ask a question. So when the school board was presented with the conflict, it was sworn affidavits by 2 employees that a school board member, the superintendent, and the inspector general had engaged in corruption or some other type of activity which violates school board policy. Typically, if the IG would not have been included in that, the IG would have been able to do the inspection, to do the investigation. So the board authorized an outside inspector general to answer the questions that our IG would have answered had she not been conflicted. And that was to determine whether the 2 affidavits that were filed were substantiated, unsubstantiated, unfounded. We paid $226,000 to Holland and Knight to determine whether or not those allegations against me or one of my colleagues, the superintendent or the IG, were founded, unfounded, unsubstantiated, or substantiated, and your report did not address those. That was the sole purpose in my mind, and I'm sure my colleagues, if they could speak today, which they won't because of ethical reasons, I think that was the only reason we authorized it to go to outside IG, is because we needed those allegations answered, because otherwise, without an answer, it looks like we swept this under the table, and someday somebody could say, well, there was allegations against the school board, the inspector general, and the IG, and that was never answered. None of that was ever answered. So I had asked I asked the general counsel to go back to you and have you modify the report, just come up with those answers for the school board, so we had clarification on exactly those issues, which were the only reason I thought we were authorizing $150,000, which turned into $226,000, to get you to do the work. And I was told by the general counsel that whether you agree or not, that you would not do that. Now you're telling that, if you would have done that back then, we probably wouldn't have been here today. But I was told that you would not change your report, to add an addendum to indicate whether those allegations, which were the only reasons you were hired, were substantiated or not. So I don't understand why you wouldn't do that upon the request of the general counsel, unless the general counsel wasn't truthful with me and didn't ask you to do that. So
No, I'm sorry, I didn't mean to interrupt.
no, I would like to know why that's not in the report. As the other audit committee members asked, why isn't that in the report? That was the most significant reason, the only reason that you were hired. Not to review you could have reviewed anything in the district you wanted to. RIG has the authority under board policy to review anything they want to review. So you could have reviewed the Pincos file, the Latson file, any file in the district, anything you wanted. But the end result was you needed to give us answers on those 3 allegations against the superintendent, the school board, and the IG. And we didn't get that out of your report. Forget about all the addendums that are attached. It needed to be in your report because that's the answer that the school board needs.
And if there was confusion about conveying those answers to you, I apologize, and that falls on me. That's not but I am certainly glad to provide, as I have today, my view, and I'm glad to supplement in writing my view very succinctly, that there was no corruption by you or your fellow board members or the Inspector General's office or the superintendent. But I felt that it was important to identify the reasons that the report would lead the subject of the report, who was unfairly maligned in my view, to make that allegation. If I were to just say, oh, I conclude there's no corruption here, without giving the background as to why someone would make that type of allegation and why they would feel compelled to come forward and say those sorts of things, I don't think it would have the support that the documents lend to that sort of conclusion.
And I'm not arguing with you. All I'm saying is, you can put anything in your report you want as to why it happened the way it did, but you needed to answer those questions, because that's why, in my opinion, you were hired. If the scope of the contract wasn't sufficient to give you that, I apologize, because that came out of our general counsel's office, but the reason you were hired was to give us those answers. You could give us 400 pages of backup of why LaCava or Vicki Evans-Bray felt that there was something going on that shouldn't have been going on, but in the end, you needed to answer those questions. So I'm asking you to amend your report to submit to the Audit Committee and the school board, indicating that those sworn affidavits by 2 employees, which, by the way, they're sworn affidavits, there might be some consideration as why would they indicate sworn affidavits without any evidence presented to indicate, that's a whole other story. I want that report amended when it comes to the school board that says that you did not find any ill acts, any ethical violations, anything with respect to the school board, the superintendent, and the IG. That's what the board needs.
And I'm glad to do that. And I think to go beyond that as to whether her allegations were improperly filed, I don't think there would be a support to say that she did that for some sort of improper or malicious reason. I don't, without any further investigation, I could tell you that I think she felt she had a credible basis to raise that claim. I have investigated and found that claim to be without merit, but what drove her to make that claim was the fact that the report was in error and improperly tarnished her reputation. Now, that was my finding and continues to be my finding, and I'm glad to have a written supplement to that effect to submit to you, Mr. Talley, if that would be helpful to you. I'm glad to do that before the end of this week.
Mr. Shepherd, if I may, I know you discussed the thought process behind what Ms. Evans-Bray believed, why these things were happening. But there's very specific allegations of discrimination, retaliation, that are specific to, for instance, like the superintendent. And the superintendent, those issues are separate than the Pincos report or the Latson. Those are issues completely unrelated that should be addressed in some sort of fashion, but the superintendent was never spoken to. So to have these allegations in writing, very specific, from the 2 individuals, which is now part of a public record, which was released, unredacted, with home addresses that should have been redacted, that is now out there, and we have a report from your office that is based on a 30-minute, 45-minute interview with me and none of my staff or none of our working files, and no input from the superintendent. We never identified which board members were supposedly taking money. We don't identify, whether or not the demotion or move.
If I could just interrupt, just so it's clear, there was no allegation. When you say taking money, I don't want a casual listener to think there was an allegation that bribes were being paid to anyone.
Fundraiser, donations.
Right.
Okay, but there was money mentioned in there.
Yes, I agree.
Without having answers to those specific issues, if you look at the 2 affidavits and you look at the report, giving a general statement of, we didn't find anything, well, if you didn't talk to the superintendent, you didn't talk to the people that were witnesses for the different issues. You didn't delve into the other issues. I don't know if, as the IG, my responsibility is to the public, and that we have not misspent money on not addressing the allegations that is in the public's interest. But instead, we have done a second opinion of our report. So to me, that is a gross waste of public funds. And if a person would qualify as a whistleblower, I think I would, by notifying of this gross waste of public funds.
I think one of the question I want to ask is, did you determine that the complainants were, by law, whistleblowers?
I determined that at the outset, they sought that. But as the process went on, they did not.
But I don't see that you made reference to that in your report at all.
I'm glad to address that in the supplement. That would be helpful to you, Mr. Chair.
If I may, please, regarding that whole whistleblower and your determination that you made because Vicky was concerned that the report might not be made public, and that's why he no longer wants whistleblower protection. Seems easy to come up with that now, but the reality is I actually reached out to Vicky regarding whistleblower. I have a signed consent, as is appropriate process for doing these types of things in whistleblower investigations, where she actually gave me her consent, and she knew the consent was the release of her name and the full report, as also required by our standards, as the standing inspector general at the time, to make a whistleblower determination. And we have standards that you're required to follow as that conflict inspector general, which require preliminary assessment, a sworn recorded interview, a full analysis, determination letter sent out, so you can prove that you actually did a full whistleblower analysis. It's insufficient to now come and say, yeah, I thought about it, and no, it doesn't fall. That does not meet any standards at any office of Inspector General. I've been with 5. I've been doing this for 30 years. It is severely lacking. Also, in regarding to the facts, as you mentioned earlier, the Inspector General did not, at any point, this is important for the Audit Committee members, find Vicki Evans-Perret guilty of retaliation against Bob Pincus. It is not in the report. The actual findings is unsubstantiated retaliation against Vicki Evans-Perret. It was adverse personal action as delineated in our School Board Policy 302. As far as the facts of the witnesses in the parking lot, there was one witness. She was interviewed by the Inspector General's office. She came in and told another witness. That's the witnesses that they interviewed. Regarding the Gunster law firm, the adverse personal action was taken in November. The Gunster report came out the following February. So for now to say we did not have a factual record because we didn't take all of Gunster into consideration, which was done after the fact, months after the fact, they released the report. Okay? So, and regarding Tom Gonzalez, while he may have provided some guidance in the scope of her investigation, in her sworn recorded interview with me, I asked her who set the parameters of that investigation. And she said, I did, based on my 20 years of knowledge working in the school district, I set the parameters of the investigation. After the fact, then you can say, well, Tom Gonzalez was involved in all great and everything. But that's not what she said. She did it on tape. Those tapes are all available for you to receive. No, your office did not listen to any of the tapes because I have the tapes and they were never requested. So we did not develop a full factual record, but you never came to us and said, what is your factual record? Let me listen to the tapes. What did they say? You just made some type of analysis and gave an opinion. We can both agree. We can look at a set of facts and come with separate opinions, okay? But to say that we did not develop a full factual record based on documentation that came after the fact, I think is erroneous. And the issue of the whistleblower has not been addressed. These 2 former employees, who by statute are still afforded whistleblower protection when requested and has not been done properly, is step number 1. Step number 2, you have to develop an investigation plan. If you look at our report, Audit Committee members, throughout the report, we're stating statute, policy, and governing directive. There's not a single statute, policy, or governing directive in your report, sir. I don't see it as an investigative report. In my opinion, it is a book report of our report, is all it was. And I realize it's final, it's not going to change. We disagree on the findings, but the bottom line is, we did not find them guilty of retaliation. It was adverse personal action based on school policy. Thank you.
Kathy, did you?
So I'm at a point where, excuse me, we were asked whether we're going to accept what was given to us or not. And everyone has made some certainly valid concerns. For me, I'm spoiled sitting on this committee. The questions that were asked would be, is the superintendent, all the corruption issues? That was not sufficiently addressed. And I would have expected it to be addressed the way our IG addresses all the issues. Mark, you brought it up at the last meeting, where here it is, here's the accusation, here's what we did, here's what we found. I read a lot of stuff and spent a lot of time hearing stories that I already knew. I mean, we're back to 2018. People have moved on. But I also see people's reputations at stake. And that really bothers me. So as a committee, I would like, unless you have more questions, to make a recommendation that we don't accept this as it is. Because I can't live with
Is
it.
that I second that motion.
But I have a couple questions first. For your report, did you find any violations of section A1 and A2 of the IG policy?
Sorry, I don't know section A1 and A2 off the top of my head, if you tell me what those are.
Well, that's the scope of services that you were hired to provide.
Well, the scope of services that I was hired to provide was to look into Palm Beach School District as it related to OIG case number 20-12 and Pinellas County 20-27.
States here that it's to investigate violations of section A1 and A2 of the IG policy, and to investigate any criminal violations of section 7B of the IG policy.
And I found no criminal violations.
Where is that in your report?
Again, my report points out what I believe were the factual shortcomings of the IG investigation, which is really the cause of the complaining witnesses' allegations of crime and corruption. I find no crime and corruption, but instead find that the report had shortcomings.
But I'm just going by the scope of services that's in the contract.
Right.
Yes.
And you don't even know, you said you didn't even know what the scope was.
Well, I have the scope of services right here in front of me.
So my only question is, if the conclusion to these violations are not in the report, how much of the report falls under the scope of services?
I believe that the scope of services was to investigate Report 2012 and Pinellas Inspector General report. I did that. That's what I was tasked to do. I did that. The question was there corruption that led to those reports? My finding is no. The reports were in error, but not because of corruption. And as the chair has asked, I will supplement that by the end of the week so that as an addendum to this report, that exists as well.
Okay.
Excuse me. When the scope was set for you, and you said that you were to look at the two reports, the one that Pinellas did and the one that we did, were you informed that the scope really, what the intention was, were the corruption allegations, not those two case numbers? Did somebody say, no, don't look at the corruption, just focus on the IG report?
No, and in fact, as your office would, I can't accept limitations on what I am to look at. In fact, if there had been limitations and I had been told you can only look at this set of emails or only look at this set of facts, I probably would have declined the engagement.
Because one of the things that I found was that Dr. LaCava's affidavit is nowhere in anywhere of the 700 odd pages. I wouldn't even know if that had been reviewed and to what extent. The policy, and my concerns were that the IG policy and the standards set everything from the 20-day responses to confidentiality to redaction to the CFA standards were not followed in this engagement. Did somebody tell you not to follow our policies or our internal operating procedures, that you could disregard those?
I understand the words you're asking, but no, I was the conflict inspector general. I conducted the investigation in a way that I thought was appropriate. I interacted with Dr. LaCava and Vicki Evans-Pere in a way that I thought was appropriate and consistent with my obligations.
Okay, because one of the things that we looked at was the scope, and it says you're supposed to follow the IG internal operating procedures as well as school board policy. And the way that this investigation was handled is nowhere even close to what the internal operating procedures required, which were set forth in the scope. The interviews were not sworn recorded. When you spoke to me, it was prefaced as a discussion. I thought you were just getting background information. I had no idea that that was my subject interview. When the report was released to everybody, the confidentiality and the integrity of the investigation was violated. Only the subjects should receive the draft report. Somewhere in the final report, it says the goal of the IG policy was to give everybody who gave a statement a chance to speak. That's completely inaccurate. And I'm concerned that somebody misled you, or that there was something lost in the translation somewhere, because the CFA standards were not followed. You're stepping in my place as the conflict inspector general. You'll follow the CFA standards, follow the IG policy, and the scope of services, and I'm not seeing that, and that's my concern. And that was my concern that I brought forward to everybody. So did you?
I think I answered your question.
Okay, so you didn't follow the IG policies. You didn't follow the internal operating procedures or the IG policy.
What I did is I conducted the investigation. I spoke with the people who were the whistleblowers, who initially raised the questions and raised concerns, as we've discussed at length. And I found that there was no support for their allegations of corruption.
Mr. Shepard. Mr. Chair?
Yes.
At what point did you make that determination in your investigation?
Well, frankly, it was sort of it was an arc of understanding, right? When I initially read your report, I thought you were accurate. It all seemed to make sense. It was not until we got deeper into it and found that there were these fundamental things that were relied upon that were not supported by evidence that I looked at, that I felt your office had not looked at,
Okay,
that
so
I began to change my view of that.
at what point was that?
I couldn't give you a specific date.
Okay, because.
I couldn't, I mean, I interviewed 20 people. We reviewed.
Who are those people?
I don't have the list of it here, but we have a list of it.
It would help if we could see their names in the report, wouldn't it?
Well, it's certainly a public record.
And were minutes taken of these interviews?
Notes were taken.
We've never seen those. Were the witnesses under oath?
I don't know that any of the witnesses were under oath. I don't believe so.
So I guess going back to the question when you made that determination, you mentioned when you were introducing yourself, you worked as a statewide prosecutor. And you have experience in handling.
Yes, I was an assistant statewide prosecutor, and then I was the statewide prosecutor.
Yeah, right. So you understand charging documents, obviously.
I do.
In this case, you had two sworn charging documents outlining one of them. Ms. Evans-Perry's outlines it count by count, Roman numerals. At what point did you determine that there was, it sounds like, I don't want to put words in your mouth, but it sounds like there was no evidence to support the allegations of corruption that were alleged in those charging documents? At what point did you make that determination?
I think it would be different as to different points of it, right? Are there?
Well, did you ask
Are there,
at the beginning, or?
as I'm sure you've conducted investigations yourself, as the process goes on, you get different pieces of information, you speak to a different witness. I don't have a specific date to answer your question.
Right, but usually, though, if somebody makes an allegation, they carry the burden of presenting facts to you to support that allegation, right? Did they ever
Well,
present to you any facts?
But you're confusing a prosecutor's burden of carrying the burden of proof with a witness or someone who calls 911.
Respectfully,
That's not, it's not the responsibility of the person who reports the crime
Oh.
to be able to carry the day,
But
or
that's
the
an
person who reports to an inspector general to be able to carry the day.
That's an
They have
interesting
to-
analogy, though, if I may. I'm sorry.
They have, if I can just finish, they may not have visibility into all things, right? They have visibility into what they can see and make an allegation and have a good faith basis to do so.
Correct. Now, you mentioned 911, and I think that's great, because the way that I kind of look at this whole thing, and I'm concerned the way the public's going to look at it, is you had two people, one of which was written a ticket. Essentially, out of 5 allegations, there were 2 that were substantiated. That again, we've painted this picture of this really stressful, hectic situation, and our office found that, look, you violated the code of ethics and you took adverse personnel action. A speeding ticket. It seems like the person called 911 in response to that and claimed the house was on fire, claimed there was a home invasion robbery going on, and when you showed up, they said, oh, we're not going to talk about that. Let's talk about this ticket. This ticket was wrong. And it seems like lots and lots of energy was focused on that, and everything else going on wasn't addressed. So respectfully, I feel like if someone does call 911, and I'm sure you've maybe prosecuted cases like this before, if you present a false report, if it's apparent early on that there are no facts to support that, your work is done, right?
I would agree that if there's not a factual predicate for a claim or a report,
What was the
that
factual predicate here?
it doesn't meet an initial, well, as to which point?
As to the corruption.
Well, there were a number of specific allegations as to corruption. Board members knew the Pincoses. Yes, they did, but I didn't find that the board members who knew the Pincoses and their involvement was somehow corrupt. They worked together. They've worked together for years, right? If somebody, but because Miss Evans-Perret viewed it through her own lens, right? You're concerned about your office's reputation. I understand that. This is not an indictment of your office. This is a focus on one particular investigation, right? I understand it's personal to you. I didn't mean for it to be more than it needed to be, right? But it was personal to Vicki Evans-Perret as well.
But there's a difference, though, isn't there?
I think you're both entitled to the same sort of protections.
Would you agree, though, that it's pretty rich to claim that our office didn't look at the entire we didn't create an entire investigative record, right? We didn't look at Tom Gonzalez, even though, as I understand it, I didn't miss that one. He never advised Vicki on how to handle Bob Pincos. He never advised Vicki on whether or not she should write a memo or whether she should transfer.
But the underlying issue as it relates to him and his involvement with Vicki Evans-Perret is the jurisdiction for what Pincos was complaining about, right?
But Mr. Pincos, you would agree, he asserted an ethical concern that our policies specifically forbid taking adverse personnel action in response to that, don't they?
Yes, I agree with that.
So then again, if we substantiate that allegation based on those facts, how can you say that Tom Gonzalez's input was not part? What if I told you we looked at those emails that were included in your report and we considered those? Would that change your conclusion?
It would, in the sense that if you tell me that Tom Gonzalez was not truthful with me, that would be significant. Is that what you're saying?
No, not at all. What I'm saying is, how would your conclusion change if I told you that Mr. Restrepo reviewed, and I reviewed, and the IG reviewed the email communications that you cited in your report involving Miss Evans Perry and Tom Gonzalez? What if we'd seen
Well,
those in front of?
then I, as Mr. Restrepo said, investigators look at two sets of facts and may come to different conclusions.
So that wouldn't change your,
Well, hang on. If you told me that you had been aware of that and then still rejected Vicki Evans' Perret position on that and said there was essentially an incongruency as if she was somehow being deceptive, I don't know how I would react to that. I mean, it would seem inconsistent that you would know about that and come to that same conclusion. But as Mr. Restrepo said, investigators can look at things and have disagreements about it.
certainly. And again, looking at the safety concerns, right? You would agree, again, if I told you that we already discussed it had been a whole week between the parking lot incident with Mr. Pincos and the transfer to South County, right? There was a whole week that took place, correct?
There was a week between that, yes, and Dr. LaCava's car had been moved into the protected area. I mean, the district took it
Right.
seriously.
And if I told-
It was not, Mr. High, if I could, the district took it seriously. It was not as if this was some made-up pretextual thing by Vicki Evans Perret to move him to South County.
What if I told you that in the sworn statement, Vicki Evans Perry said that when they have incidents like that on campuses, they immediately remove the person if they believe them to be a threat? Would that statement surprise you?
It would not. I understood from speaking to the detective who was involved in it, and others, and frankly, having worked in law enforcement for, almost 15 years, there is a continuum of crisis. I mean, FDLE physical presence at the scene is a level 1 use of force. That can accelerate instantly to a maximum use of force. Situations are fluid.
So
I
allowing
understand that.
Allowing the person to stay for an entire week before you submit the transfer memo, you would agree that belies any.
I disagree with you. And I also Mr. High, I also disagree with you that the fact that Mr. Pincos's wife was still allowed to work in the building because there was somehow some consideration in the Inspector General's office mind that Mr. Pincos could get his wife's ID and somehow get back into the building, that just seems inconsistent with due process as it would relate to one employee just because their spouse has an issue of discipline or threats within the district. That made no sense to me, that you undercut the credibility of that transfer based on an analysis that it couldn't have been genuine because Pincos's wife was allowed to still work in the building and he could have taken her ID. It just did not seem consistent.
I'm actually somewhat confused in the thing. There's the email here where even, I guess, Bob asked, like, you didn't answer my question regarding adverse action. And Vicki said, we will address that issue like at a later date. I mean, isn't that a violation right there? I mean, shouldn't she basically be saying, no, there's not, I mean, you recused yourself, you're allowed to recuse yourself. And like, I'm just curious. And that, I feel like that email kind of stood out to me a little bit in your report of just feeling like that was kind of not probably the appropriate thing Vicki should have said. No?
Can I go back to the original premise of do we accept, do we not? I made the motion. We can have discussions about
We have a
details.
motion and a second. We're still discussing. Is there any further discussion then on the motion? Restate your motion.
That we do not accept the report as given to us.
Okay, and Mark.
And Leandre second that motion.
Okay, is there further discussion?
Well, I'm curious, what does that mean the next step is, though? Because I don't like the idea of saying we have to go get it, because I agree wholeheartedly with, I think Frank kind of said it or alluded to it. There needs to be some sort of report, right? So there needs to be some conclusion to this. So I don't like the idea of saying, well, let's go find someone else, let's go spend more money. Is this are we basically saying we're not accepting this and we want Holland Knight to fix it? Is it basically, because I think we need to be very specific on what we think our thoughts are on that, if that makes sense.
I think was the report conducted on these two inspections under the IG policy, and then what were the conclusions? And I say If we don't think that it was conducted under those scope of services, then we don't accept the report.
I think that the next step, if determining, I think by IG standards, you need to list what the allegation was, what steps were taken to either prove or disprove it, what interviews were done, and any alleged violations, substantiated or unsubstantiated. I believe that needs to be done for every allegation which falls under the premise that for corruption, wrongdoing, and abuse, which is the only reason why we send these things out. We don't send them out for a second opinion, but we need to have the answers for the public as to is the superintendent, myself, or unidentified board members acting corruptly? And it needs to be specifically answered towards that. And then the discussion on how we ended up spending this kind of money and not answer those questions, that's something that's going to have to be determined in another point. But there's very specific allegations in those sworn affidavits that need to be answered that are public records.
So I have a question. Is it appropriate and can we reject this report as given and request that it be reissued addressing the allegations as you've so properly stated?
Yeah, but you would have to show evidence that this allegation was looked at, what was done to look at this allegation. I don't believe that it's sufficient to say, while looking at A, I didn't see corruption. While looking at B, I didn't see wrongdoing. You have to actually look, was there wrongdoing? Did you ask board members, did you use improper influence on the IG? Did you ask the IG, were you influenced by, did somebody put pressure on you? Did you ask the superintendent, did you take these actions, did you demote, or did you remove somebody based on something from a board member? And those are the things that are silent here.
And I guess, oh, I'm sorry. I'm just saying, that's my concern, is I'm not sure that was done with the 220,000 or whatever that was spent. So that's the concern of saying, where I was concerned about next steps and future. And, correct me if I'm wrong, feel free to, but
Which is why I made the motion to not accept it. And then if there's other motions that we want to make, it would seem in my head, then we make another one so that we
Okay,
don't
well, at the
get
moment,
all
we have a
confused.
motion and a second.
I just think that there's not going to be a conclusion to this, just because it doesn't appear that the report was done under the scope of services. So to have it done under the scope of services, you'd have to start from scratch almost. So essentially, I think you just say we don't accept the report, that it wasn't under the scope of services, and that's where you leave it.
Okay, I'll amend it to say that such,
Yeah.
that we do not accept the report because it did not appear to be under the scope, and keep saying it, Mark.
Conducted under the scope of services.
There
Is
you
there a
go.
second?
Second,
Wait, let me ask,
Okay, Leandra,
let me
you
make
had a
let me-
comment before we.
Yeah.
I'm amending the motion.
Mr. Chair, I have a comment.
Before this becomes a little too convoluted, I think first, if this is just me, there should be a motion to do the addendum as outlined, or the supplemental information as outlined by the chair, by the board chair, one. Number two, we're not accepting the report as presented today without the supplemental information along with the actual scope of services not being followed. So we need the supplemental information first from Holland and Knight in order to close out this report so we can get some closure. But we're not accepting this report as presented today because those deficiencies, as Mark outlined, are not there. So that's, I think, one, and then two, will bring us some closure to this without having to revisit or spend any additional public resources to move it forward. That's just my thought.
Okay, well, we have a motion on the floor and a second. Is there any further discussion?
Well, with that thought, is there a new motion?
Beg pardon?
With that thought, is there a new motion? I mean, that,
If,
amended it.
if we could,
Amend
if Catherine
did.
don't mind rescinding her motion at this moment, and let's entertain that motion, the first motion for the supplemental information from Holland and Knight. And then we can go that way if, the maker of the motion don't mind rescinding her motion, taking it off the table at this moment. And so, yes, I may be out of procedural.
I kind of agree with what you're saying. I
order.
mean, he's offered to kind of make some amendment to it.
Right.
Don't we want to see what that would be? Because now I think he has a better understanding of what we're looking for and
Yes.
how it responds. I think that's a very fair motion to say,
Right.
yes, please. I think you mentioned by the end of the week, you could have that kind of adjusted to kind of address concerns we have on our side. So I would be entertaining a motion to say, let's wait, pause the week and let's get a revised report and take a look at that.
We have first a motion on the floor to reject.
I'll second the rejection.
So is there further discussion on that? Then let's vote on it. All those in favor of
Aye.
rejecting the report as presented?
Aye.
Aye.
Any opposed? Passed unanimously. Okay, now let's go on to,
So then can we have
Yeah.
would there be the argument to then have a new motion to say, can we allow for an amended report from Holland Knight to come up to us within the week? Is that,
Kathy?
With specific information that we need.
That was discussed.
That was discussed.
That was
Yes.
discussed. I mean,
Yes, that was discussed during this
corruption
meeting.
seems to be the biggest issue, the corruption issue, and the scope of services reference in there, that has to be specifically identified.
As well as abuse of power. That was the other allegation that I think
Okay.
needs to be addressed. And it was in Holland and Knight supplemental memo that there was no abuse of power. So I think those.
We also have the
that has to be-
discrimination, too.
All of that
Whatever-
has to be
whatever-
addressed in
whatever,
the
yeah.
supplement.
Right.
For us to be able to, for the school district and the school board to be able to act appropriately in the public, to still have trust in what we're doing.
Now, I think if I'm thinking, Frank's going to say it shouldn't be as an addendum, it should be just total
new-
revised
a new-
report. And
a
I think
new-
that's a fair comment, too.
A new report.
I don't want to put words in Frank's
No,
mind.
all I'm asking is,
We got
if
it.
the committee's going to ask for a new
new
amended
report.
report or new report, I just want to make sure every single allegation in those two sworn affidavits are answered, every one of
Okay.
them. It's not just corruption or intimidation, it's everything that Perez said and everything that LaCava said, all those allegations against the school board, the superintendent, and the IG, every one of those has to be addressed as to whether they're founded, unfounded, substantiated, exactly like RG would do if she was doing an investigation on an employee in the district.
Yes.
Right.
So are
I
you
agree with
willing
that,
to do
yeah.
that, sir?
Well, we have to make a motion.
Well, I just don't think that the conflict around the errors and omission, it all resolves around, per the investigation, all resolves around professional judgment, in my opinion. And since the investigation wasn't conducted under the scope of services, under the IG policy, which I believe, I don't think we'll ever come to a conclusion on that. And I just think that that's going to be the one issue that I think is just going to be left up in the air. And instead, because we're not going to pay for another report.
Well,
but I think-
So,
I'm so sorry.
so I just want to state that I just think that part of this, this investigation is just probably not going to be resolved.
Would be part of like you're saying it, but as a committee, we've said we've rejected it.
Yes.
So that would be inclusive in that, and I don't want to get lost in that. What I want to do is bring some real finality to all the conversation we've had today so that it's in print and becomes public record, and then we can put it to
Yes.
rest.
We just need a conclusion on the allegations.
Right.
Yeah, so, and I think
Absolutely.
he's willing, Holland Knight's willing to do
Yes.
that. So I think that's the motion is, what we've discussed, the parameters we set, that's my motion, and I'm entering that we get this revised report and we review that.
Okay, I'll second that motion.
okay, is there any discussion on
Close it.
that motion?
No.
All in favor?
Aye.
Aye.
Opposed? Passes 6-0. I guess Tammy's gone.
Tammy had to go.
Okay. With that, are you in agreement to amending the contract with the things that Frank has mentioned, specifically that Frank has mentioned, and that we've discussed to bring back to the committee?
Yes, Mr. Chair, I am, and I appreciate the opportunity to do so.
Thank you.
Okay, thank you all. The last thing is that the board meets tomorrow, and we're going to need to have someone give a report to the board. Unfortunately, I'm not available, and Tammy had said that she, as vice chair, she'd be willing to give the report, and I just want the okay from the committee to have Tammy as vice chair give today's report to the board tomorrow.
We
have a
support
motion
that,
on
Mr.
that?
Chair.
We all support it.
fine.
Okay, discussion, all in favor, all opposed, passed unanimously. Okay, the next regularly scheduled meeting is April 21st. We'll be in touch with you after we received an updated report by Mr. Shepherd. Mr. Shepherd, you and your associate, thank you for being with us today. Thank you, board.
So wait, would I imagine then, are we going to probably meet before April 21st then? Because we're going to get this,
I said.
Okay, sorry, just wanna make sure.
Scheduled meeting. I didn't
Okay.
say, yeah. We
Next week,
probably
yeah.
will meet before that.
want to make sure I understood, sorry.
Okay. Is there any further business? If not, I recommend a motion to adjourn.
I make a motion to adjourn.
Second?
Second.
Meeting adjourned. Thank you.